Introduction. The concept of Malay reservation land was first introduced by the British in the Federated Malay State of Perak, Selangor, Negeri Sembilan and Pahang in 1913 to prevent land held by the Malay in the state from being disposed of to the non-Malays. Malay's Reserve Enactment 1913 was repealed and replaced by the Malay Reserve Enactment 1933. Then in 1935, the Malay Reservation Enactment 1933 has been revised and reissued as a Malay Reserve Enactment FMS Chapter 142, and this enactment used until now. Other states subsequently also create Malay Reserve Enactment respectively. For example, Kelantan Malay Reserve Enactment 1930, Kedah Malay Reserve Enactment 1931, Perlis Malay Reserve Enactment 1935, Johor Malay Reserve Enactment 1936, and Terengganu Malay Reserve Enactment 1941. And for your information, in addition, British did not hold any Malay Reserve Enactment in Penang and Malacca. Differential. In general, land in Malaysia categorized into freehold land, leasehold land, and Malay reserve land. So, focusing on Malay reserve land, Bumiputra lot is one of the types of land where most people consider it the same as Malay reserve land. But in fact, these two things are different. Bumiputra lots are open for sale to Malays, Sabahan, and Sarawakians, and also non-Malay Muslim, while Malay reserve land are land that can only be owned and held by Malay and transacted between Malays. Next, any land that were declared to be a Malay reservation must remain as Malay reservation until it is otherwise declared and gazetted as being revoked by the parties concerned. While in freehold land, the ownership of the land is perpetuity. Perpetuity means that there is no time limits for the owner, and the freehold land lies with the title holder until he transfers it to someone else. But leasehold land is different from the others. The typical maximum lease period allowed is 99 years, although the newer development in the market have managed to get lease period extending 100 years. These cases, however, rare and few between. The shortest lease period allowed is 30 years. Besides, Malay reserve land is often considered second class by society. Any form of development and the transaction will be effected on Malay reserve land can only involve the Malay only. This leads to the low bargaining power of limited market. Meanwhile, freehold land is seen as the top choice of many as they assume the ownership over the property is permanent forever. Buyers have the notion that this type of housing can be owned forever in the buyer's family and can be transferred from the one person to the next generation without any hindrance from federal or state government authorities. Despite the fact the government still has the right to reclaim any land, whether freehold, leasehold, or Bumiputra lot.
Malay reserve land issues and challenges. Problems that have existed for decades have yet to be resolved. While there is legislation to protect Malay land proprietary interests, shortcomings in its enforcement have prevented total Malay reserve land area from attaining the desired level. It has been a good 105 years since the Malay Reservation Enactment 1913 was enforced, but the core objectives behind its implementation have yet to be achieved. There are even allegations that over the decades almost 4 million hectares of Malay reserve land have changed hands and yet to be replaced. According to the Wasiat Raja-Raja Melayu that materialized just before Malaya attained independence in 1957, 50% of land in the Federated Malay States was to be alienated as Malay Reserve. The first issue and challenge is second-class land. Under the Malay Reservation Enactment 1913 covering the Federated Malay States of Selangor, Perak, Negeri Sembilan and Pahang, all land declared as Malay Reserve land cannot at any time be sold, leased or handed over to any person who is non-Malay unless it is declared and enacted to be void by the State Chief Minister. The responsibility for the implementation of this enactment was passed to each state government, which has the authority to designate any specific area as Malay Reserve land. The other 5 Malay states implemented their own Malay reservation enactments at different times. Kelantan in 1930, Kedah 1931, Perlis 1935, Johor 1936 and Terengganu 1941. Reports of MRL shrinking to critical levels started emerging when such land, much of which was initially situated in rural areas, came under the jurisdiction of the local district or municipal council, which inevitably swelled its development potential. Unfortunately, land classified as Malay Reserve mostly remained undeveloped due to the unflattering second-class land label. In contrast, non-MRL enjoyed higher market values and extensive development. In view of this situation, several Malay Reserve landowners and interested parties willingly arranged to have the status of their land revoked in order to enhance its market value and competitiveness. The next issue is not assertive enough. In terms of legislation, Malay Reserve land is well covered, but what is glaring is the lack of assertiveness in enforcing the relevant laws. Failing to replace MRL land that has had its status declared void was essentially due to the enforcement authorities not adhering to the relevant provisions or outside interference. University Technology Mara UiTM Senior Lecturer Dr. Muhammad Hasrul Hafiz Aliasa said there was a provision which required the land officer concerned to insert a reminder in the Malay Reserve Land title document that in the event of revocation, the land must be replaced. Failure to do this will lead to a fine of RM 100. This provision is just not firm enough to protect Malay Reserve Land. The RM 100 fine is too low. It should be raised to a more deterrent level. The penalty should be either a fine or a jail term, or both. This is because the officer concerned has contravened the law by failing to insert a reminder, he said, noting that the Federal Constitution did not provide for any form of penalty that can serve as a deterrent in terms of enforcement. Such action is important in order to increase the percentage of Malay Reserve land. The last issue is multiple ownerships and size. Many Malay reservations plots have multiple owners, while some are of uneconomic size for cultivation or development. It is based on Malay inheritance laws and tradition. The property has multiple and fragmented ownership. The situation worsens because Malays having no written wills, not even those with substantial estate, as attested by many high-profile inheritance disputes. Similar to other Malay reserve land, Kampung Baru is facing the same problem. There are approximately 12 owners on 16,000 square feet of land. Few years ago, UDA Holding has conducted studies on the area, found out that a quarter acre is occupied by 72 owners. It means that there are between 4 to 10 owners for a housing plot on average. Multiple ownership has significantly reduced the marketability of the land. Because the multiple ownership is a factor that produces transaction costs, particularly the time needed to get collective agreement and the opportunity to get better land value. In addition, the holdings are small, averaging about 10,000 square feet. The land is uneconomic size for cultivation or development. Development is impossible unless pieces of land are amalgamated together. However, consensus is generally hard to be reached to to achieve economic land size due to the different mentality and attitude towards development.